We are referred to Employee State Insurance Corporation versus Union of India. Then Town versus Signer by Oliver Wendell Holmes of US Supreme Court. We have also referred to UGC guidelines. We have also referred to Maharashtra Public Service Commission versus Sandeep Sriram Varade. Then we have referred to care on fraud because Mr. Ratho argued on fraud also. We have referred to S.P. Changalavarai Naidu versus Jagannath. Then having considered all aspects of the matter, we are allowing the appeal like this. In the above circumstances, this appeal succeeds. The impugned judgment of the learned single judge is set at naught. The first respondent's WPC number is dismissed. Courts having been made easy. Yes.
Open to 3,146 of 2025.
May I please, Your Lordship?
Yes, sir.
In this case, Your Lordship, the appellant was.
Drag the mic.
May I please, Your Lordship? In this case, Your Lordship, the appellant was working as a pescar in Major Settlement Office, Cuttack Jobra. Subsequently, by 2018 resolution, he was deployed to Cuttack Collectorate as an RI for a particular purpose of high-tech survey. But after some time, my lord, by a order dated 23/6/2025, he was relaxed.
It as revenue inspector for all purposes.
Yes, yes. That matter is covered by Your Lordship judgment also.
There's one judgment we have rendered. No, that matter. Just look into, will issue notice. Just look into, thorough copy on the other side. It will come in the first week. Issue heard. Learned counsel Sri so and so who argued well. First off, a case is made out for issuance of notice, especially keeping in view this bench's decision in writ appeal number so and so between this board of so and so. First off, learned AGA, Madam accepts on request accepts notice for the OPs. First off, matter lies in another compass and therefore need not be kept pending for long. First off, call this matter in the second week of August 2020. Start.
Challenge order dated 19/8/2025 passed by the OERC, my lord, rejecting my application claim of the compensation I have claimed against the opposite party in person of the statute. Clearly
Compensation for what?
For non-payment of my refund, my lord. Refund of allowances, my lord.
Non-payment of refund.
Yes, my lord.
Excess payment was there.
No, my lord.
Then,
My lord, transformer was installed, my lord.
right.
As for the agreement, my lord, when the agreement was terminated, my lord, he only refund my amount.
Oh, you mean to say that is the amount returned for security?
Yes, my lord. Security deposit, my lord. So I'm sorry, my security deposit has to be. Security deposit has to refund, my lord.
It has to be refunded.
Yes, my lord.
This is the petition.
Yes, my lord.
Why they have not refunded the security deposit? Forfeiture clause is there.
No, pursuant to your lordship's order, the copy of the writ petition was served today at 10:30. I've gone through it. Once the dispute remains that he is entitled to get a security deposit after it has to be reviewed in every 1 year or 2 years.
Periodically, that has to be reviewed.
If it turns out that he is entitled, he has paid more than what he should pay, then it has to be refunded. That is point number 1 of refund. Or when the entire power supply agreement terminates, then we have to refund him the security deposit. These are the two methodologies where we need to refund the security deposit. and if there is any delay on our part in refunding the security deposit, interest. Now, my lords, admittedly, it was not refunded. That is what is written against which he challenged before the grievance redressal forum. The grievance redressal forum passed in direction to refund the security deposit along with interest from a particular period to a particular period. Since that was not complied with, he approached the learned ombudsman, the higher forum. The learned ombudsman also reiterates what GRF said. Thereafter, Malats, due to non-compliance of the order, he has gone to the OERC, that is Odisha Electricity Regulatory Commission, under section 142, because we have not complied that order. When the matter was there in the OERC, Malats, the amount was paid.
But no interest was
Interest was paid.
Interest also was
paid. His grievance was the interest would have been supposed to be paid at the rate of 15% per annum, which admittedly it is written in the petition that it was refunded around 4.5 to 5.5%. That is there.
That's very
Thereafter, while the notice was issued, Malats, another notice was issued that you remanding matter to GRF to see whether it has been actually complied with now. So far as the calculation is concerned, GRF said no, it has not been properly complied. You pay the differential amount. We paid the differential amount. Also, when matter was pending before the OERC, the petitioner was himself present. He said, I am satisfied with the compliance. Accordingly, the matter has been disposed of. Now, Malats, as I have gone through the writ petition, he says, no, it doesn't amount to a valid compliance because some amount is left. What I Malats,
and how much you harassed him?
that is there.
See where all he went. So the very harassing the citizen is the ethos of your state. That's what people who follow Jagannath should do.
Respectful submission is, this is what I've gone through the writ petition. I've not taken instruction because it was served at 10:30.
You will take instruction and
Yes.
come back. All right. But this is nothing but harassment of the city.
I'll take instruction why it has been done. If anything comes out other than what is written in the writ petition, I'll appraise your lordship.
Heard learned counsel appearing for the petitioner and learned panel counsel appearing for the OPs as well. A perusal of the records make out a prima facie case subject to what the other side would say on the next date of the first time. Hereafter consider the opinion that the interest paid on the amount that was to be refunded in time is too low to be mentioned. First option. 15% may be too high as well. First up, a golden balance needs to be struck between these two. First up. Next one, the above apart, we notice that the petitioner has been harassed like anything at the hands of the OPs, prima facie. First up. However, it is open to the other side to rebut the same on the next date of you. First up, call this matter in the second week of August 2026. What kind of harassment? In your state, there is a lot of harassment to the people. Yes.
Number 4, WTC 5278 of 2026.
On behalf of learned religion, the paper possible.
Whatsoever. All right. But this is for admission.
Parents.
So, have you entered caveat?
No.
No. Then wait, why you should be heard? Admission is matter between appellant and the court. You are nobody unless you have entered caveat.
May I please, Your Lordship? Lordship, the petitioner is a Group C employee of CBI. He is of 58 years of age, less than 2 years of service left. He is being transferred from Bhubaneswar to Srinagar.
My brother, how many years of service you have put in?
I have put in more than 38 years of service.
38 years.
Yes, Your Lord.
Transfer on the count of administrative.
What administrative? 38 years he has put in. Maybe you are little older than 38. There should be a limit for harassment in the last leg of his service. 2 years. What apex court said? When an employee who has served very long, he is at the fag end of his service, should be treated with soft gloves. Heard. Now you have been relieved or yet to be?
I have been relieved, but I am on commuted leave.
Or you are on committed leave?
Yes, Your Lord.
Heard from the counsel appearing for the petitioner. First off, he submits that his client has put in about 38 year long and spotless service, and that he is going to retire within a short span of 2 years. First off, that being so, his client ought not to have been subjected to transfer. First off, there is force in this submission, and therefore matter requires deeper examination at the hands of this court. First off, in the above circumstances, the application in IA number
1896.
1896 having been 1896. Yeah.
1896.
Supported by affidavit having been favored, the OPs are directed to put the petitioner back to the earlier position and office as before within 2 weeks, but failing which the defense of the other side may be struck off and petition may be allowed by taking the averments on their face value. First, of course, this would, of course, the question of taking back the petitioner to the position would happen after the expiry of the committed leave, unless he cuts it short. Unless you cut it short, okay? He comes it short. That's not the right. Yes.
May I please, my lord?
Yes.
My lord, the petitioner is challenging me before my lord the notice under section 13(4) that is take the symbolic possession, my lord. The backdrop of the case in short before my lord.
Now, what is the amount? What is that backdrop?
My-
You tell
my
what is
lord.
the amount taken? What is the nature of loan?
My lord, nature is CC loan, my lord, by pledging the house, residential house, my lord.
How much? When?
That is 24/9/2005. The amount is, my lord,
You borrowed it in 2005.
I have deposited 2 lakhs,
When did you take the loan?
my lord.
Hmm?
14/1/2002, my lord.
14/1,
2002.
22, my lord. Sorry.
22.
22, my lord. Rest 31/9,000, my lord.
31 lakh?
90,000, my lord. Then, my lord, loan account number,
All right. Account number.
My lord.
Yes, what is the amount you have repaid?
I have paid, my lord, 2,16,000, my lord, deposited counter file annexure 2, my lord. So,
Deposited.
I have-
Credited or deposited?
deposit, counter file deposit karchi, 2 lakhs.
Deposited, yes.
Deposited, my lord,
Against
on against the loan, my lord, page 20, my lord. Then,
Paid back.
loan. Paid.
then, my lord, it is strange and surprise, without intimating me, they have declared a NPA, my lord. I have approached to make the one-time settlement, giving the reasonable time, my lord. Without giving that, they have issued notice, my lord, demand notice on 9/1/2026, that is under section 13(2) of SAHOO Act, my lord. Then, my lord, on 17/3/2016, symbolic possession, my lord. I have prayed before my lord to stay that symbolic possession, give the opportunity for one-time settlement. No court action, because that is my residential house.
Why you gave residential house as mortgage? Who told you to give mortgage, the house for mortgage? You have given it and it suffers the mortgage.
So I am ready
Residential
to
house is not
pay.
factor in.
I am ready for one-time settlement, giving.
But they should be ready. How can you force one time?
No, no, my lord. No, I am praying.
Correct, but you should make prayer to the bank.
I have said to them. But
What
as
is
they
the
have,
amount due, brother?
Copy that sought to me.
You
No,
copy.
no,
You copy. You copy.
46,74,222. You're outstanding.
46 lakh.
46,74.
You pay 30%. Will stay further proceedings.
20%.
No bargain. This is not Cuttack vegetable market. There is a
And I
stand.
am serving the copy. Serving the copy, my lord.
The grievance of the petitioner is against coercive action of recovery. First up, a complaint is made as to certifying the account as NPA unjustifiably. First up. Though initially 31.90 lakh was borrowed way back in January 2022, presently the outstanding appears to be rupees 44 lakh plus. Yes. First up. Counsel for the petitioner in all fairness agrees with the proposal of this court that his client could be crediting 30% of the outstanding if reasonable installments are given, and that he would also press for one-time settlement as well. First up, he submits that if the interim protection is denied, his client would be put to manifest injustice and hardship. First up, a prima facie case is made out for issuance of notice and also interim protection. First, learned counsel Sri so on request accepts notice for the bank. First up, he opposed the grant of interim prayer. First up, however, opposition pales into insignificance in as much as in several such cases, this court has granted interim protection, and therefore the petitioner borrower cannot be singled out when bona fide is being demonstrated by making the offer as mentioned above. First up, in the above circumstances, application having been favored, the coercive proceedings are halted, subject to petitioner paying 30% of the outstanding amount in 5 equalized fortnightly installments, failing which not only this protection withers away, but petition also may be rejected on that ground per se. Next.
Item 6, Government 2061 2026.
Yes.
In this case, I have the function and other things matter. The essay is pending by the annexure 6 series at page 39.
It was of essay.
Madam, essay is pending since 2025. The IA has not been taken up till that. Neither the objection has been filed, nor the IA has been taken in the.
Your borrower.
I am for the borrower. And in the meantime, the sale has been done.
Petitioner borrower is knocking at the doors of writ court with the following prayer. First of all, learned counsel for the petitioner very fairly submits, and we agree with the same, that right to speedy justice being one of the facets of Article 21 of the Constitution of India and the right of curtain of decisions of the apex court. The direction needs to be issued to the DRT Cuttack to take up interim application filed in SA number
86 of 2025.
25 on a war footing. First up, notice to other side is dispensed with, since it will have full opportunity of participation when the said application is taken up for consideration. First up, next paragraph. It is also necessary that main matter 2 is heard and disposed of as early as possible, of course, keeping in view the seniority and other pressing works. First, in the above circumstances, the petition is disposed of with the above observations.
Only the IA may be within a stipulated period because the option purchaser may change the
IA to be in said SA to be considered within an outer limit of 4 weeks. All contentions.
I may be protected because
Registry to send
not
a
to
copy
change
of
the nature and character only.
No protection is granted.
Because it is during pendency of the essay, only I pray nature and character should not be changed. That much.
Hello, your lordship, while dismissing the writ appeal, I directed them to implement the order within 8 weeks by the lordship can see page 43. Within a period of 8 weeks, driving the respondent to not to drive the respondent to contempt.
For the first time it has come, somebody should notice.
Your lordship can see page
Also police notice. Returnable within 2 weeks, call the matter 4th of August. Yes.
privilege.
Well, I heard the need to put Mr. appeal for the complainant. Okay.
I commit also press one.
First time it has come.
Yes.
First time this has come, but
Police notice.
may be pardoned. Earlier, there is an appeal from the order of the land single judge. Single judge had directed to pay the amount of 26 years of pension, which was pending for the last.
Now we are issuing police notice. Let them come and say.
Short
Police notice. Let them within 2 weeks call on. Non-service of notice by the police will be viewed very seriously. Put that sentence. Yeah.
Document 2019.
Judgment dated.
Compliance report is
No matter. It's the second date, your lordship. After the judgment, last it was listed last week, then it's the second time.
And you wanted an affidavit relating to compliance of your lordship's order.
No, other day,
Your lordship also directed that. That we have not filed, my lordship, it will be some more time. So that
And
we have communicated them, but they have,
but they will not obey.
they will, my lord, give me some time so that I shall pursue them to.
They will not obey you. We know your officers. They understand only my language. They will not understand language, sober language at all. They need to be.
My lord, I'll talk to them today. Today I will talk to them instead of issuing
Your
letters.
letter, AGA, Mr. G, submits that all endeavors should be made for reporting compliance. And in that correction, he is having, he is conferring with the official, the officials concerned. First off, believing these words, the matter is posted to 4th of August 2026. First, non-compliance will be viewed very seriously, and even an order for arrest and detention of the violators of the order may be directed. In addition to a direction for making adverse entry in their service register.
your lordship, while in judgment, your lordship reluctantly made easy for cost, my lord.
It is only a metaphor in English.
And my lord,
Yeah.
after
Let us. Yes, 4th of August.
Item K, appeal 1329 of 2024.
I am respondent one.
What is this? Point number 1.
Madam,
The state appeal.
state has filed appeal, madam.
So to argue?
Madam.
Item 10.
Yes. So observing in the, what is wrong with this order? He has been working since 1990 on 44 days basis. Means what?
Continuous for 34 years.
44 years. Every 44 days. This is very, very unethical on the part of the state.
My lord,
Break every 44 days. Artificial break.
it was, there is a break.
44 years. Sorry, how many years? 1990.
34 years.
Since 9.
35 years.
Your lordships,
No, absolutely not.
Well, during judgment, already 32 years already.
You want to spoil the matter?
No, madam.
Then sit down. Unless you want to give a ground to him from your ill arguments. No, Mr. J, nothing like that.
my lordship, may you call this matter some other day so that. I know.
Madam, I have objection.
Call on,
Madam, madam, I have
Why are you arguing? You are not in KV. Are you in KV?
Well, 2002,
Are you on KV?
no, madam.
Keep it. Then where is the say for you? Admission is always a matter between the appellant and the court. G seeks a short accommodation. Call on call on 4th of August.
Yes.
But there is nothing.
I know that.
Covered by judgment also. They are 1991, so stop your teachers, lecturers judgment, 91 Supreme Court. Yes.
That is some Rabindranath Mahapatra, Justice R.N. Mishra's judgment, 91 Supreme Court.
91 Supreme Court. You are right. Where they were every once in 30 days, they will send put on artificial break. Okay, just look into that judgment. AR 91 Supreme Court. Yes. Next.
Here also, my lord, your lordship challenging the order dated 6/5/2024, and writ appeal, intra-court appeal has been preferred, my lord. There, your lordship directed that this order will settle it.
Scale of pay.
Yes.
What is the differential? Instead of 630, you made it 370.
370.
That was challenged before the learned single judge.
Yes. Only lordship may condone the delay, but it may hurt.
Well, after a period of 34 years, my lord, they have refixed the pay, and after retirement of the respondent, my lord, and the petitioner is not getting final pension, is only getting provisional pension, my lord. He is 69 years old, my lord. And after the gap of 34 years, my lord, they have refixed the pay. And that after retirement. And he's not getting his gratuity or anything, my lord. Only provisional pension is getting.
Paragraph 6 of the order, your lordship may correctly say. Having heard learned counsel appearing for the parties, considering the materials available on record, this court finds that the petitioner on his appointment as Hindi teacher in the year 1984, his pay was fixed in the scale of pay 400 to 750. As further found from the record that petitioner's scale was revised from time to time as such, a revision was made in the year 2009. The petitioner, therefore, while continuing, retired from service and attaining the age of superannuation on 31/3/2017. As found from the record, after such retirement,
You cannot do that.
the petitioner, basing on a complaint made by the
Some association.
yes,
Maybe he had not voted in favor of particular candidate in the association election. Therefore, he shooted
they
the
have no
letter.
election, they have no association.
How can you do this? After how many years? You want to dig the grave of Alexander? How? Get down. This intra-court appeal by the state and its officials is directed against the
In the pension rule, there is a provision, they can do that.
no, that
What is that?
not
What is-
pay, not pay. Pension you can do, not pay. That one. Against against a learned single judge's short order dated 6/5/2024, whereby
68.
respondent employs WPC number OAC 3114 of 2018, having been favored.
78 or 68.
The following relief has been accorded to him. See that? Next paragraph. Appeal has been preferred after broking delay of 147 days and seeking its condonation application in IA number 7836 of 2026 accompanied by an affidavit is also moved. First up, we find some plausible explanation in the delay application, and the learned counsel appearing for the respondent employee is agreeable for condonation of delivery period. First up, therefore, application having been favored, the delay is condoned. First up, next paragraph. At para 6.1 and 6. At para 6 and 6.1, learned single judge has rightly observed that first up, the pay was fixed way back in the year 1984, and that is thought to be 84, and the respondent employee attained the age of superannuation for retirement on 31/3/2017. That being the case, the alleged pay anomaly could not have been made good at this length of time, at least as a concession to the shortness of human life on the earth. First up, in the above circumstances, appeal being devoid of merits is liable to be rejected, and accordingly it is coupled with the direction to implement the impugned order of the learned single judge within an outer limit of 6 weeks, failing which stringent action may follow in the next level of legal battle. Next.
So you are referring to 68(2).
Yes.
68(2) speaks about the government dues as ascertained and assessed by the head of office, which remain outstanding till the date of retirement of the government. You can't hold it.
That can't be done. It's not due. Next paragraph.
Item 12,
Wait till now.
page 04 of 2023.
No, there is a delay of 600 days in preferring the appeal.
You are the appellant.
Yes, madam. The compensation death case, my mother has died.
Your mother died when?
Died in 2017.
How that will, from how many children mother has got?
But first read petition was disposed of to file a fresh representation. There are second read petition was filed, that was rejected on the ground that fire officer has stated that she has committed suicide, but the investigating officer of police has stated that she died due to fire caused in the house. And the delay was Milord.
What the collector say?
Collector Milord says that
Page 16.
What one since?
basing upon the report of the fire officer, collector has rejected the claim.
Third paragraph.
How can for suicide can they?
No, police has stated that there is no due to fire, there is no suspicion of any foul play. Page 1.
Report, sir. Death by all the scriptures to take Quran, Bible, Janda Avesta, the Torah of Jews, all they prohibit suicide. Manusmriti says Atmahatya Mahapapam. If that is so, that is the reason why Lord Macaulay made an attempt to commit suicide is an offense. Human life is precious.
Yes,
Not cut it short.
That
was now she has committed suicide. You want for committing suicide? What
no, police have stated that she died due to fire and there is no foul. When is suspicion of foul?
Inquest report is there.
Inquest
report is there. They have referred to that inquest report. Collector has referred to inquest report. No,
they refer to the report of the fire officer. But a police
report is created unless the report itself is shown to be wrong.
Yes,
show it wrong. Then will it?
Page 313. 13 last paragraph. Report of final for 1P13. Final for. The investigating officer stated that under the above facts and circumstances, I am declaring the cause of the death of the deceased Hon'Ble Behra, wife of Akro Behra of village so due to extensive burn under no suspicion of any foul play.
Therefore, it is suicide.
It is ultimately.
No, this is
the. Not at this stage, no.
Now, this is the report of the investigating officer.
But it's a disputed question of fact now.
How can we hold the inquiry whether whether death is suicidal or homicidal.
The fact finding authority, the police, my lord, will say. Police has not stated that this is a suicidal case.
The inquest report is there.
Only fire officer stated that tried to attempt come to suicide, so there was a fire and died.
Now,
They shifted injured to the hospital where she died.
now when the death occurred?
Death in 2017.
The date of the death, you don't have every whole year she will die. On a particular day she will die.
The date, my lord, 7/6/2017.
17.
And you made the claim on which date?
Well, I made the claim on 4/1/2022.
You should have waited another 10 years. 4/1/22.
4/1/2022.
What is the explanation for the delay?
Delay, my lord, village woman, she was not knowing about the benefit of the government, 2015 guideline of the government. After knowing,
Where have you
my
stated?
lord,
Where have you stated?
in my application,
Have you stated that? Show that.
No. Your case is something else. And that was the brief.
first one I have no, that is not with me, but the second one, after disciplinary reputation, Hon'Ble court direct to make a fresh representation. So I filed a fresh one, that is an extra 3, page 14.
This intra-court appeal is directed against learned single judge's order dated 11/7/2023, whereby petition appellant's WBC number 1919190 of 2023, claiming a direction for payment of compensation has been negative. First off. Next paragraph. Having heard the counsel appearing for the parties and having perused the petition appeal papers, we decline indulgence in the matter, broadly agreeing with the view of the learned single judge as has been reflected in the impugned order. First off. Next paragraph. The above apart, we notice from the records that the lady concerned met her maker on 7 June 2017, and the claim for compensation was laid on 4/1/2022. First off, thus there is a delay of more than 4 years in making the claim. First off, there is absolutely no explanation offered for the delay and for the long delay and latches. First off, that apart, the learned, the concerned competent authority, namely the district collector, has entered a finding that the death of the lady concerned was suicidal. First off, this opinion has been formed by the collector on the basis of the inquest report. First off, whether a person died because of suicide or homicide is a pure question of fact, and the writ court cannot undertake a deeper examination of the same. First off, next paragraph. In addition to what is stated above, we notice that the appeal has been preferred with a delay of 610 days. First off, the explanation offered for the delay here in the accompanying application supported by the affidavit is far from being plausible. First off, long delay cannot be condoned merely for aspirants, said the apex court in a number of decisions. First off, next, in the above circumstances, appeal being devoid of merits, the same is liable to be rejected, and accordingly it is. Okay. Next.
13, 1, 2, 3, 4, 5, 6, 7,
13, my lord, it is the state appeal. It's a delay of 207 days. But my lord, question is the order so passed by the Honorable Single Judge dated 7/1/2024. It is at
7/11 or 7/1?
7/11. 7/11.
ML Kesari is followed.
ML Kesari followed. But one crux of the point is, in fact, the appointed in the post of research assistant. Then subsequently it was redesignated as research officer in the year 1987.
When he gained entry?
11/11/1987.
87.
Yes.
Uninterrupted.
Yes.
Uninterrupted service. Then that would fall into Dharwad Daily Wages case.
Yes.
So which is repealed only
Only one point I have. Question is, they are all the way appointed under a particular rule of 91. Did you kindly have a glance to page 64 for a moment?
How 91 it can be when he was appointed in 1987?
No, my lord, there is a provision. The persons, those who have been appointed as a demonstrator, the next hierarchical post is research assistant. Then they will be treated as a research officer, my lord. These persons, for a particular period, without following the due procedure, have been appointed in 1987. I can say it
as research assistant.
Research assistant.
And they have worked as such.
Worked as such. My lord, then subsequently research officer also. And date of retire is 2019.
Educationally qualified.
Educationally qualified.
They have qualified. They have worked against the post itself. And no complaint whatsoever. Service is long. What Jago says.
No, Jago says everything.
Jago says you should Jago.
Jago. Jago to Dharam Singh, we have nothing to say.
Shripal.
Jago, Shripal, Dharam Singh, then last one is the Madan Singh. Bholanath Milan.
Dismissed both on.
But at that point of time, there was no such sanction post. Only for
that you have said you only have argued the other matter.
I am restricted to do so.
Main matter. Dharam Singh, Dharam Singh, Jago
Shripal.
To be mentioned. The impugn order of the learned shall be given effect within an outer limit of 8 weeks, dwelling which a stringent action may follow for contempt action. Okay.
Item 14, PW13399/2025.
Item 14, it's a matter of to antedate the date of appointment they are claiming, my lord. Some documents required in this case, that is the notifications.
First of August.
That's it.
Shut the question.
Christian Miller, it's a state appeal. And the challenging the judgment dated 23 August 2024.
87 appointment.
Yes. But subsequent to one, because that was a composite college, one post was existing, PET. Another person is continuing who is at respondent number 4 in the writ application.
Therefore, learned single judge said, in any other institution also, not necessarily in that.
To that effect, may I take instruction? It will be Monday, Miller.
Monday.
I don't prefer more time. Monday.
5th of month. On request.
Already, in the meantime, they are pursuing the content Miller till Monday. Miller.
Call this matter on 4th of August. In the meanwhile, contempt proceedings shall be kept in suspended animation. Yes.
Item 16, I may permit to withdraw your lordship during yes, your lordship. During the pendency of the matter, your lordship, the bank misplaced was disposed of, your lordship, by learned district magistrate.
Is it?
The matter became
counsel appearing for the petitioner seeks leave of the court to withdraw the petition as it has become infructuous on the action of the bank itself. So, ordered accordingly, a petition is disposed of as we go.
Item 17, WBC 154/2014.
My lord, this is a bulky matter which may take much time of your lordship at this juncture. We would stick that on behalf of the state.
My lord, I am for the petitioner. Already the case has been heard. Only the judgment is also given from my side.
The doctor,
My lord,
doctor matter.
doctor matter. It is completely hard. Final judgment.
VRS matter.
Not BRS.
No.
He is resigned from the state.
Resigned and joined M.
He resigned
You have dismissed from service.
government job and joined the Bhubaneswar AIMS.
AIMS. That was the argument.
I remember.
Yes, we remember that because he had argued that matter. And permission was granted to him to join also.
It is on the basis of a direction of the state, probably he has not been taken in there. Or he has.
He has he has joined, but we have relieved him.
You have relieved.
Here they have relieved him without following the due procedure. They have terminated me from the service. That is what I am challenged. Under the guise of the relief, the person who has relieved me is subordinate to me in scale. Forget about the. I am a central government class 1 officer.
Then it may come on Monday. I will come prepared.
Why?
On Monday.
How many years it will take?
No, only
15 years.
Hard by your lordship. Lordship remembers everything.
My lord.
This Monday.
Let me
Monday also.
my lord,
Monday it will come before us.
my lord, why not? Today I am submitting one thing. On 12th May, it has been hard and it has been fixed on 14th May for their side to submit any case law in their favor. But inevitably the case was not listed on 14th May. Thereafter it is decided after vacation. Today, what is the problem of taking further time?
No, I am not, because I was not the conducting counsel then. I will come prepared. I will assist your lordship for dismissal. I don't.
On 9th. My lord, on 9th.
Huh?
On 9th.
On 9th.
This matter of 9th.
My lord obliged.
Yes, sir.
Lordship, remember it is that matter where the senior advocates have been prepared even for that mediation. Mediation, Mr. Mohanty, Ashok Mohanty and Mr. Buddhadev Rao.
We had requested them to mediate. No,
Mediation has been done.
done.
Yes, but they said that we will be submitting the report. And they'll say that they'll be submitting the report today. So,
We'll have this matter.
can it be tomorrow or day after? Tomorrow, Your Honor.
Yeah.
No, tomorrow, Your Honor. Day after. Yes. Tomorrow. Yes.
I don't know, bro.
Yes.
So only say that the report may be submitted today.
Yes.
No, kal ki bhi.
Wait. No, call day after. We'll do it day after. Call day after. Awaiting report of the mediators.
Your Honor, day after there are 2-3 matters.
Tomorrow.
Friday no problem.
Friday.
Yes. Tomorrow. Your Honor. Tomorrow. Your Honor.
Wait, what happens within 2 days? Why you so much?
No. Day after tomorrow there are.
He does not want to reach your lordship's bench.
No. Buyer receipts.
Yes. You will not do like that.
No, never. It's not a case of bench hunting. Never.
No, question of any hunting.
Right.
Friday, Your Honor?
Yes.
Item 19, legal break. Judicial Court of 2024.
आपण तो पहले लीड करते गवर्नमेंट में गवर्नमेंट से
My friend was to respond because I had the other day I had pointed out to your lordship.
Okay, if you
That-
leave me, I can make some.
It's over. Just will you freshen our memory?
Yes. There were 2 questions which were.
Whether
He had the
the
qualification.
certificate is obtained, it's a fictitious certificate or not.
Yes.
You say it cannot be a fictitious certificate. Anyway, I cannot be blamed for obtaining such a certificate. That's your case.
That is one.
Number 2 is even otherwise the qualifications which you have would meet the requirement. Therefore, even if the certificate is ignored, your position will not be affected.
Should not be affected. That is my case.
That's all.
That's my case. And I had shown to, if your lordship wants to just revisit those documents by which I had shown to your lordship how I am qualified for the post.
What was the qualification?
The qualification, my lords, here, my lord, the
Post, what is the post? What is the qualification required?
My lord, if your lordship can hear from the beginning of the case, can appreciate. He was appointed through advertisement through the regular recruitment process, programmer cum training officer.
When it was?
That is in 98.
Whole year he was appointed.
And that is pursuant to the advertisement.
Which date?
6/1/98.
This was pursuant to advertisement.
Pursuant to advertisement from the index of the writ appeal, your lordship will find. Serial number 2.
Dated?
That advertisement dated 31/7/97.
Yes.
Then he continued in that post. Then he was he was given in charge of system analyst post.
On?
That is on 13/3/2006.
No, 28/9/2005, the petitioner was kept in charge of the post of
Yes.
28/9/2005.
Then, my lord. And that system analyst post, that it was a vacancy was there, it was adjusted there. Then
He was absorbed in that.
no, he was allowed to continue in that post because he was lying vacant.
He was absorbed.
Absorbed.
Yeah.
On which date?
On 31/1/2006.
Yeah, you can sit and answer. This is not primary school. You are all senior advocate.
13/3/26. I find Annexure 3 from his writ appeal.
Absorbed on Mr.
31/1/2006.
But copy of order dated 13/3/2006.
Yes. Yes.
With effect from 31/1/2006.
Yes.
Why the order dated 13/3/2006?
It also not? Oh, yes, yes. It is with effect from 1/3.
That's what he said.
Yes. Well, this system analyst post was redesignated as assistant director, MIS.
It was redesignated. On which date?
That is
5/12/2006.
5/12/2006, and that is as per the 23rd Executive Committee decision dated 5/2/2006. That is Annexure A/3 we have given in our counter to the writ petition, and that is also
Annexure 4 to the written.
Annexure 4
Redesignated as?
As
assistant director.
Assistant Director.
MIS.
Yes, sir.
Then the moot point is that what is the qualification of assistant director? Then your lordship kindly come to this was decided after this upgradation of system analyst to assistant director. But that assistant director qualification your lordship will find here.
Is it the case of redesignation or upgradation?
It is a upgradation.
What the word used in that instrument?
That is
Don't add anything on it. Because everything will have
Redesignated.
Yes, that I state bring your lordship notice to Annexure A/3 of the counter of the writ petition. 291.
Annexure 4 to the writ appeal.
Annexure 4 is that is the extract. That is the extract. 291. Your lordship kindly find
Hereby redesignated.
Yes.
Why do you use upgradation? Where is the what?
Redesignation. It was decided to redesignate the post of system analyst.
In service law, redesignation is one thing, upgradation is another.
Assistant Director, MIS, equivalent
to the post of
Assistant Director in view of
Because it is equivalent post.
work group.
They have equated also.
Yes.
System
Then Lordship kindly for a moment hold the counter of the writ petition. This is the question to be decided. Lordship kindly, page 307, 30 of the writ petition.
307.
Yes, sir. Of the writ petition.
The running page.
Running page. Internal page is 31.
31. Okay.
Internal page is 31. But running page 307. And this is
307.
yes. And this is the document and
Staff
B by 3.
This is staff structure.
Yes, yes. Lordship kindly see page 307. Then Lordship kindly see serial number 12 in the table.
Not done.
This is Assistant Director, Public System Analyst, MIS.
This is dated.
This is dated 15th executive meeting. Your Lordship will find page 303, dated 20th January 2004.
What is this restructuring?
This is the proceeding of
This is
the
the
executive committee, 15th executive committee, and certain proposals were mooted in course of the meeting, subject to approval of the state. The approval never happened. That
State
is
has
what
not given approval.
yes, that is exactly what I had argued on the last one.
That is approval question does not arise.
No, but you have sought for approval.
Pardon?
You have sought for approval.
No. So, that is, Lord, ultimately, everything that is already, government has done this thing. Government has approved.
Where is that?
Then the executive committee, the chairman is also the chief secretary, and vice chairman is the school and mass education secretary.
No, did you ask for approval?
That
very page. That very page.
No, that was nowhere pleaded, no ground is taken therein.
Your Lordship sees
The document itself is saying that. Your document.
Your Lordship sees the very same page, just before the table, the last line. So the following staff structure placed for approval of EC. Thereafter, my lords,
for approval of executive committee.
This restructuring has come on which date? In 2004.
2004.
Huh?
20th January 2004.
And thereafter you have redesignated in 2006.
No, pursuant to this. Pursuant to this.
Then where is the question?
Pursuant to this.
Then where is the question?
Pardon?
Then where is the question? You are redesignating the person
Yes, we have redesignated.
after 2 years.
Redesignated. The question is that Lordship kindly see the qualification. That I beg to draw Lordship's attention to qualification is right side column. Right side column. Diploma mean
Is it with retrospective effect? Is it with retrospective effect?
System analyst, he was there.
system analyst, he was there, but he does not possess this quality.
Why? You can change qualification of High Court judgeship
2004
from Harvard University.
This is
Can
the-
you deny pension to me on that ground after my retirement?
This is 2007.
Yes, but he was made with effect from 31 January 2006.
System analyst.
Yes. Which is equivalent to assistant director.
One post was vacant. That is why he was given in charge of that. Your Lordship will find the OSEPA rule says, Rule 5, it will be through direct recruitment and through employment exchange or by open advertisement. His appointment first instance as programmer was through the advertisement. But here, he was transferred to OSEPA office and there he was given some officers then has given the charge of system analyst.
Have you taken action against those officers?
No, that we have not. That we have not.
What is
No.
his fault?
His fault is he does not possess that qualification.
Where is the question of possessing qualification?
Because
Your qualification came into effect on which day?
that is 20th January 2004.
Huh?
20th January 2004.
And after that only there is.
You designated fully after knowing everything.
That is all right. But system analyst post is on 13/3/26, 2006.
31/1/2006.
Now 13/3.
That is
All right.
notification.
All right.
Officer.
That is with retrospective effect from 31/1/2006. That's what you said. We have written that. Read that. You will know what you have said.
13/3 is with retrospective.
Sorry, perhaps some communication gap maybe.
No problem.
Maybe. My Lord, Lordship got this. This is
Now he has been
That is in
demoted from a
January.
system analyst. Demoted.
No.
I was actually.
Demoted from system analyst to
Programmer comes
To the
pending up.
You cannot do that. How can you
Because-
cannot do that?
Because by that time, whatever qualification he had,
You-
accordingly, pursuant to the regular recruitment process, was selected and appointed.
How that qualification is applicable to him? He has already been absorbed. You have looked into everything. You said this post is equivalent to that post. You would redesignated it and you absorbed him. End of the matter.
But 2004 is the decision of the executive committee. He was appointed in system analyst post in 2006.
Correct.
2006. That system analyst post was redesignated as assistant director.
Correct.
And for that assistant director, already 2004 qualification is this.
But were you blind when you did it?
Pardon?
Were you blindfolded when you did it?
You only did it in 2006.
You only have done
your
that.
own instructions. You have not your own instructions.
That we have done.
Then
But something,
you
some
penalize.
irregularity is there.
No.
All that
But
becomes regular by passage of time.
But one thing, Lordship, can listen. But he has taken advantage by producing a document, the certificate, to have that qualification to continue in that
Now,
post.
how that qualification will apply to him now? You having absorbed and redesignated, he is enjoying the post, rightly or wrongly. How can you unceremoniously reduce him in rank? Read Article 311 of the Constitution. 9, 10, 11.
Yes, that is all right.
Reduce that.
I am conscious of
Simple applies.
I am conscious of that. But a person is holding this post, my lord, being a pick and choose.
How long?
My lord,
How long he has been holding the post? With effect from 31/1/2006. No, actually he came to be placed in charge on 20 September 2005.
He was in charge, then he was absorbed.
20 September 2005. Thereafter you absorbed him. You gave him the permanent status. And now you want to alter the position to what? When?
he was no, that is only in 2006.
Mr. Mahathir,
No.
2004 may not know.
Not to that.
2004 was
Impugned order is dated what?
24/12/2020.
20. Mr. Mukherjee, you should thank him that they have not done it after your retirement. 24?
2020.
impugned order is base 25.
After how many years you want to do this?
This is after 15 years. In
At
that.
least as a concession to the shortness of human life, you should have done it within a year or two. After how many years you want?
At your lordship is absolute right. While there was a hue and cry, so many complaints came
So anybody-
that irregular appointment, lot of irregular appointment have been made because so many programmer were there. Programmer come that training officer.
Where is that 24/12/2020 order?
That is annexure 24/12. That annexure 8, page number 35, 33 to 35 of the written fee.
That is annexed to him.
Should be from page 34. Last paragraph.
Office order.
Yeah. Part is this part. This found also that MCA was a requirement. That is also not there in the neither in the AICTE guidelines nor in the
Master of computer application.
Sorry, Manoj.
Master of computer application
Yes, Manoj.
was not a requirement.
Not a requirement.
Yeah, whatever requirement that I have shown to your lordship.
What is the requirement?
The requirement is, it is,
They are referring to the 15, that is the 2005, where they say the degree in Bachelor Computer Engineering.
degree,
Previously,
degree in
Bachelor of
computer engineering with knowledge of management information system.
But he is saying MCA is necessary.
Not necessary.
Then your order is wrong. Yes.
That, he has passed electrical engineer. Your lordship, kindly see another serial number 14, 15, 16. There is another post, that is assistant director, assistant project engineer, for which engineering is required. Bachelor in engineering.
No.
But this post, for this post,
MCA is not necessary.
MCA is master in computer application. That is the fake document he has submitted.
No, it's solid. That is not necessary at all.
MCA, that is equivalent to this qualification.
Who has equated?
That
You have equated. London single just dismissed the petition.
he allowed the petition, just allowed me to continue in that, in the previous post.
No, that means dismissing the petition only.
In effect, yes.
No, that cannot be.
Whereas after personal hearing to see Mishra, I am
Yeah,
reading-
personal hearing every other. He says MCA is required.
and considering his so-called reply, there is no such ground to substantiate the MCA certificate as genuine.
The question is whether MCA is a requisite qualification.
Master in computer application.
Where is that?
Computer application,
It's not necessary.
if that is not necessary, he is nowhere.
But
It's the only qualification he has, which is from Nav Bharat.
question is, his initial degree certificate itself is sufficient. Because you have not prescribed MCA for the post which he is holding. Assuming your prescription applies to him, but there is no such prescription. Now you show that MCA is required.
But the MCA is like this computer application. Degree in computer application.
Degree in computer application. This is master of computer application.
Master, a step ahead.
Master means after degree of
PG. This is PG.
PG. This is
PG is not required. Now you show PG is required.
But pardon?
MCA is required for holding this post.
You have said it is only degree in computer engineering with
Engineering.
knowledge of management
That's
and
it.
information system.
With knowledge of
management
information system.
information system.
This is because he has been working in the post since long.
Yes, that is
He
right.
absorbed it.
Your lordship mean to say that without qualification also with the
We don't
experience.
know. You
With the
take it.
experience.
No, where is the qualification? You show no MCA.
But
You want to-
let him show
You
that.
want to remove him on the ground that he does not have a doctorate from Harvard University. We are asking.
No, we are not saying that. We are
Then
saying
you
that
show MCA.
this qualification is not there.
You show MCA prescribed.
He hasn't done the MIS, Management in Information System. He said possessing the degree of electrical engineering.
Where is the requirements
Postgraduate
that he should possess MCA?
degree on PhD.
You know how much time they are taking for all 2 minutes cases?
Hey, lordship, kindly see here. We have
No,
given
that
that
is not the
document.
ground on which he has been taken out. His only ground is that he has produced a fake certificate in MCA. That is not your ground that he doesn't have MIS. Why are you going to the other side?
That's all.
That's not your ground. Your ground is not that he didn't have knowledge about MIS. Your only ground is that he had produced a fake certificate. That's all.
But we have indicated that these are the qualifications.
Where is
But
it?
you have filed the
Show.
MCA.
Show the indication. Indicate now.
Indicate, my lord, that so-called explanation short for kind.
Not explanation. From your rule, you have to show the candidate should have MCA. Show that.
MCA word is not written. Not written here.
That's a subject.
But what they make it equivalent to MCA means that
No, you can
computer application degree. That is
Anything, then tomorrow again you will say after he produces MCA, then you will say that no, it is not.
that cannot be.
If you could do this, why not that? If it is on assumption, then everything can. No, it can't.
But another thing I will submit. Lordship, kindly see. Let your lordship deal with this. Kindly come to page 187.
187.
Yes, of the writ petition.
What you want to say on that?
That will not your lordship kindly bear in mind that I have not said from the beginning. This OSEPA is executing it is a schematic scheme. All appointments are made on contractual basis. Your lordship will find programmer and training officer appointed on contract basis. This post is also on the contract basis. And how it will be selected, that is lordship will find page 187.
But when you are saying all this, after how many years?
That I cannot explain.
No,
I cannot. Only we have said that because there are a lot of allegations that these irregular appointments have been made.
So
That is why, my lord, obviously the public authority is answerable. And
You
it is
answer them at this length of time we cannot do. That is the answer you should have given. You can't just please the people.
This is pointing
People
the
will say
finger.
100 and odd things.
Once the pointing of the finger is there.
There. You should have said. So you should have said many years have lapsed now. If we set aside that, we will be answerable in the court of law. You will not be coming there. We have to go before the judges like Dixit.
Right.
We don't want to take that risk. That should have been your stand.
So this contention lordship will also kindly take the 187. The method of recruitment of staff. The post to be filled up by direct recruitment may be done through advertisement, newspaper, or by calling limited candidates from the employment.
Yes, the advertisement was there.
No, advertisement was the program.
Correct.
Not for this post.
But that is only when you are directly appointing. When you are doing the things by redesignation. All that will
System analyst post is not equivalent to programmer come.
But you have said in your letter that the post of that post is equivalent. You have stated in your document. I read it twice.
No, that is equivalent to assistant director. System analyst is equivalent to assistant director.
Yes.
System analyst not equivalent to programmer company.
Not program. Programmer is the
that is gone now.
That is submitting.
That is previous avatar.
It was.
That has gone.
That is gone. But one thing is that system analyst post or assistant director post was directly observed there.
It was decided to be.
So this is the pick and choose method.
The post of system analyst as assistant director MIS equivalent to the post of assistant director in view of workload and importance of MIS. This is your conclusion.
Not programmer. I am not saying so.
We are not in program. He has already been taken to programmer, from programmer to system analyst. He had been working there. Thereafter, system analyst post was redesignated.
That is all right.
That's all.
But for holding this system analyst post, it was directly observed.
We did not say no. He could have. You did not. Now, after 20, 30 years, you will say that we have not done this. That's a mistake on our part. Now you should go.
No, that is right. That is my content, sir. That is recruitment, direct recruitment. It should have been direct recruitment. That has not been done.
Nobody has stopped you from doing that. You could have gone for a direct post. That's a direct post. Advertisement should have been there.
You did not do.
Then it was very good for the officials to do.
But another thing, lordship should be noticed also. No, lordship should be noticed.
How long your friends can wait for such a small case? They will not only they may laugh at me, with us. They may not laugh at you because you are doing very well.
My lord, we are beating our heads for this. ETA appeals are pending also prior to this matter.
What to do? Now you cannot say all that. Having argued the matter, knowing the mind.
I'm saying so.
You now say, Mr. Mohanty. You should not say that.
Well, some contempt are hanging also in the soul.
They should hang actually.
But only thing, your lordship, I must bring to your lordship notice. That he was reverted back to the programmer come officer. And since then he has not joined. Till date also he has not joined. So for that
because
period,
once he joins, he will say he has accepted the post and therefore he cannot file the implementation.
No. Pension, there is no pension is provided here. These are all contractual post. So long they work, for that period they get the.
So that is also not there.
Pardon?
So pension is also not there.
Pension not.
It is contractual. So you will be getting this salary for the period you will be working. That's
Yes,
all.
yes.
And still then.
No, still
The period we are denied. For that they should agree. They should never do to another person like this.
So that is
We are allowing this matter with cost.
Why, my lord?
Because there is an error on the part of the officers. Otherwise, they will go on like this. So you will fight the case, government will pay. They have nothing to lose.
No, we have done our duty, my lord.
Well, anything you want to say for about the cost?
To their perception, it has been done.
Yeah.
Because it does
Pay
not
1 lakh
possess
rupees
this
cost.
cost.
With cost of one
Cost will be
lakh.
harsh. Cost will be harsh.
No, harsh it should be. Otherwise, they will go on doing this like to other employees. They should never do that.
No, that your lordship can caution this thing.
No.
Your lordship can caution this.
Not caution. Caution will do nothing. Only when we give heat treatment, things will happen in your state, not otherwise. I have been here since 1 year, 2 months. I have seen a lot of these people. Sorry to say that.
My lord, our division bench is nothing but a coordinate bench also.
Therefore,
only to revise this. And already we have got the judgment also. And your lordship, that your lordship kindly consider to us.
This intra-court appeal with the employee is directed against a learned single judge's order dated 16/7/2024, whereby his WPC number 346 of 2021 has been negative. First off, in the said petition, he had called in question the office order dated 24/12/2020 made by OP number, respond number 2 at Annexure 12 to the petition, by which he was downgraded from the post of Assistant Director MIS to that of Programmer come Training Officer. First off. Next person. Learned Senior Advocate Mr. Mukherjee, appearing for the appellant, vehemently submits that his client was appointed, submits that his client, having been appointed as a Programmer cum Training Officer with effect from 6/1/1998, after selection pursuant to advertisement dated 31/7/1997, was placed in charge of the post of system analyst with effect from 28/9/2005, semicolon. He having been duly absorbed in the said post with effect from 31/1/2006, wide order dated 13/3/2006, and the post of system analyst having been redesignated as a assistant director with effect from 5/12/2006, the impugned order of response number 2. Response number 2 is absolutely unjustifiable. First off, he points out that once an employee is absorbed in a particular post, and that post is a post on redesignation is equated to another, the unceremonious downgrading of the position is unjustified.
That is response number 3.
But response number 2, you have written, learned judge have written response number 2. 24/12/2020 is by response number 2.
3.
First. Lastly, he submits the grounds on which his downgradation of the post is made are either contrary to law or non-existent in this 3. First. Next one. Learned panel counsel appearing for the answering respondents vehemently opposes, kindly sit down, daughter, opposes the appeal, making submission in justification of the impugned order of the learned single judge and the reasons on which the same has been constructed. First off, he tells that the appellant lacks the requisite qualification for the post in question, and therefore, on the allegations of the public, his official clients have made the impugned order, which on being examined by the learned single judge has been rendered sustainable. First off, that being the position, the appeal should be dismissed is his prayer. Next one, having heard learned counsel for the parties and having perused the appeal papers, we are inclined to grant indulgence in the matter for the following reasons. Number 1, there was a recruitment advertisement dated 31/7/1997, and that the appellant had staked his claim for selection and appointment are not in dispute. First off, he came to be appointed as programmer cum training officer on 6/1/1998. First off, subsequently, he was placed in the charge of post of system analyst with effect from 28/9/2005. First off, further, his services came to be absorbed in the said post with effect from 31/1/2006, wide order dated 13 March 2006. First off, therefore, the appellant had got a right of lien to the post in question, regardless of arguable infirmities in his selection and appointment. Next. 2. The post of system analyst came to be redesignated as assistant director MIS by treating the said post as being equivalent, wide order dated 5/12/2006. First off, the appellant had been working in the said position with no complaint whatsoever. First off, when this was the position, the order dated 24/12/2020 was clamped on the appellant at a bolt from the blue, whereby his position was reduced to his entry level of programmer cum training officer. First off, this is on the 2 erroneous premises, namely, the one that the appellant lacked the MCA MCA. And secondly, the certificate which he had obtained is fictitious. First off, next paragraph. Despite vehement submission, learned panel counsel Mr. Mohanty is not in a position to demonstrate that the post in question required MCA qualification at all. First off, a qualification not prescribed by law cannot be superimposed by some officials. That runs contrary to the canons of service jurisprudence. First, if that be so, whatever certificate the appellant had procured, which is said to be fictitious, pales into insignificance. Next paragraph. We need to deliberate a bit more on the certificate which the appellant has obtained after prosecuting the studies. In which university, Mr. Mukherjee? In a university, in
Navbharat
Shiksha Parishad.
Hands of Navbharat Shiksha Parishad Rourkela. That was enlisted by the UGC or AICTE?
AICTE and both UGC.
Not enlisted.
They have clarified.
AICTE and UGC as not being authorized to confer degrees of the kind. First off, merely because unauthorized institutions conferred a degree certificate, one cannot hastily jump to a conclusion that the certificate itself is fictitious or fabricated. First off, a certificate arising from unauthorized institution is one thing. Fabrication or fictitiousness of such certificate is another. First off, this subtle difference having been lost sight of, the impugned order has been issued by respondent number 2. First off, therefore the same is unsustainable. First off, this aspect of the matter has not been duly considered by the learned single judge, and therefore the impugned judgment becomes vulnerable in challenge. First off, next paragraph. We would have simply allowed the writ appeal and set the injustice meted out to appellant at naught. First off. However, that would not be doing complete justice to the appellant who has suffered at the hands of the answering respondents. First off, no reasonable person in the armchair of respondent number 2 would have issued order of the kind without ascertaining all credentials. That too, after a long lapse of more than 15 years. That is, more than 15 years. First off, it hardly needs to be reiterated that the appellant was absorbed as a system analyst on 31/1/2006, and the said post was redesignated on 5/12/2006. First off, such a long delay on the part of the respondent officials would not justify the order dated 24/12/2020 and the other consequential orders. First, in the above circumstances, one more sentence. Therefore, this is a fit case for levy of exemplary cost on the respondents. Next one. In the above circumstances, this appeal, which was heard for longer than what was required, is entitled to succeed. First off, and accordingly it succeeds. First, the impugned order of the learned single judge is set at naught. First off, appellant's WPC number so and so having been favored, a writ of certiorari issues, quashing the second respondent's order dated 24/12/2020 and the consequent order dated 16/12/2019 as well. First off, the appellant shall be reinstated in the position with all consequential benefit, service and monetary within a period of 8 weeks. 8 weeks. First one. The second respondent shall pay a cost of rupees 1 lakh.
Actually, respondent 3.
Respondent number 3.
All through respondent 3.
All right. But learned single judge has said respondent.
Maybe mistake. Maybe mistake.
We'll say as a respondent number 2 and 3 collectively pay.
Actually 3.
2 and 3 shall collectively pay a sum of rupees 1 lakh to the petitioner by way of costs for the hardship and injustice meted out to him absolutely sans any jurisdiction, any justification. First off, this payment should be made within a period of 8 weeks, failing which the same would carry interest at the rate of 1% for the first month, 1% per mensum for the first month, and 2% for the months next following. First off, the interest, the cost and interest may be recovered personally from the erring officials in accordance with law. Correct. Next. Huh?
Item 20.
The batch of appeals by the state being aggrieved by the on a single judge order directing for regularization, citing a particular case which is distinguishable from the facts of the case, that we have taken the ground that case was different and this case was different. But in fact, Lordship may kindly peruse the impugned order, last paragraph, that is the direction that your Lordship.
Arvind Kumar Srivastava is followed.
Yes. But 6.3, that the Lordship directed that he may be taken to liberal establishment, but on notional basis. That is there. That is a state is not aggrieved by that. But the fact remains that date chat, your Lordship may see the date chat, 98 is the first appointment. That we say illegal appointment, but illegal appointment continued for a long period, that your Lordship is condoning.
Correct. 99,
he was terminated from service. And from 1999 till 2012, he was not in service. He was out of employment. It's a long gap. Since 99.
First he gained entry on which?
98. 2011, 1998.
2011, 1998.
Then he was terminated on 31/12/1999.
1 year.
Yes. Thereafter, in 26/7/2012, he was again rejoined in service pursuant to order of the tribunal. After a long gap
that
of...
means 31/12/1999 order was set aside by the tribunal.
Set aside.
Then there is no such order. Once order is set aside, you have seen what the apex court said in that, which is that, some moped, Chamundi mopeds.
My lord.
If an order is stayed, it remains on record, but it is in a dormant position.
Suspended
If
animation.
an order is set aside, the order is wiped out from the record.
Then merger.
Not even merger. It is wiped out.
It is wiped.
Therefore, your contention that there is break in service, that goes.
That goes. Then thereafter another point. Lords, he accepted the engagement.
Chamundi mopeds, AR 1992 SC, SCR 999.
Yes, that is always there. Well, if that follows the order of the tribunal, the way he was tribunal directed.
That OA number?
97/2000.
Order dated?
Order dated.
No,
10th March 2000. 10th March 2000. A batch of case disposed of. And
that is 2583 of 1997.
My lord. The order is reflected in page 51 of the writ appeal, my lord.
No, pursuant to interim order, perhaps, my lord, because if 2000 is the final order, now how can 2012 he is taken into service?
Again, state file writ petition against the order by the OJC number.
This 97 of 2000 was disposed of on 10/3/2000.
My lord.
That had set aside 31/12/1999 order.
My lord.
31/12. Where is that order?
My lord, at page 51 of the writ appeal, my lord. There is the paragraph. However, since a clear stand is taken in the government counter that there was fraud in selection process, it cannot be brushed aside lightly. We therefore directed that this aspect be proved into by a high-level committee consisting of an officer of the department not below the rank of additional secretary, director elementary education, and director secondary education. Depending upon the findings of this committee, a conscientious decision be taken by the department as to whether the circle-wise selection in 2 circles should be cancelled and a fresh selection held in respect of the vacancies in which the applicants were appointed. Till a decision is taken, they should continue in their respective posts provisionally. If a fresh selection is held, the applicant shall be allowed to take part and relaxing the upper age limit in respect of those who might have become age bar. In the meantime, till the vacancies are filled up on regular manner, they shall be allowed to continue in their respective posts provisionally. But it is a clear order of the tribunal, my lord, on land tribunal.
Then litigious employment, my lord.
That the litigious employment which inures to their benefit, not your benefit. Because they have succeeded. Had they not succeeded and there was an interim order, you could have argued that way. Not when it is allowed.
There was crime branch investigation, my lord.
And what turned out to be from that?
And there was a scam detected.
Ultimately, what happened to scam? Who was prosecuted? There are so many scams, detected, undetected. But question is, what actually followed up the scam?
But the case which was cited and relied upon by the Lord Single Judge Srimati Sipra Kumari Parida,
correct,
that referring to that decision, the benefit was conferred.
Because they are same.
No, not similar footing.
Same, my lord.
Identically same.
Not identical, same, my lord. We have taken that.
Same.
We have taken that particular ground.
No, show that. How do you say it is different?
My lord, that
Thereafter, Director Elementary Education Odisha by order dated 11/8/2016 rejected the claim of Sipra Kumari Parida, which was again challenged by Sipra Kumari Parida by filing one,
challenged, it was allowed.
which was disposed of pursuant only on the ground that since no objection from the side of the State Council, and accordingly the Learned Tribunal directed to pay the applicant notionally fixed on so till her retirement. But in the instant case, the respondent, after rejoining in service in the year 2012, has never approached any court of law. Rather, he has accepted the decision of the government without any protest. That I am showing that in 2012 he accepted, and in 2023 he has come up before your lordship, the single judge, for seeking regularization. In a long gap of, my lord, 11 years.
my lord,
Between 26/12 to 2012,
23. He came in 23.
23.
26/12 to 2012, he was removed.
26/7/2012. 26/7. He respondent joined in his service. Rejoined in his service. And 26.
No. There, this is the order OA 97 of 2000. Well, do you have a copy of the order?
yes, my lord.
You that order.
So he was inducted in 11/1998 and was terminated on 31/12/1999.
Yes.
Well, rejoined on 26/7/2012.
Yes.
No, that rejoining was pursuant to what? No, in the meanwhile, there was an order by the OAT on 10/3/2000. What the order says.
So,
Interim order will continue. On FDL.
Fine.
my lord, the operative order is at page 51.
Page
51. Accordingly, state preferred OJC before the Honorable High Court by the
That was against the batch matters.
That matter, including the petitioner, my lord.
Your matter also?
Yes, my lord. OJC by the 6/4/47/2000. And the same OJC was disposed of the 2018 by the order number 19 dated 20th December 2018.
No.
That is a government order, my lord. He is referring to government order.
Order 31/12/1999 was termination.
My lord.
Correct.
My lord.
That came to be disposed of, set aside on 10/3/2000.
10/3/2000. My lord.
Is it correct?
Correct, my lord.
Show that.
Termination.
Termination he admits, 31/12/1999. What happened to this termination in OA 97 of 2000?
With the base cases, the judgment, the land tribunal directed to continue the petitioner along with others.
Till a decision is taken, they
decision is
continue in
taken.
their respective posts provisionally.
In the meantime, the petitioner.
Till inquiry is correct. But against this OJC number?
6447 of 2000 and 2000 disposed of on dated 20th December 2018. In the meantime, petitioner was rejoined, allowed to rejoin.
You resigned only on 26/7/2012 is his version.
My lord.
What happened to the interregnum? 31/12/1999 and 26/7/2012.
They did not allow us to join. Did not allow. They did not carry out the order of the land tribunal. Rather, they preferred appeal before the this honorable court. In the meantime, again they admitted and allowed to continue from 12 provisionally.
But appeal OJC was pending.
On pending of the OJC. Thereafter, on 2020-21, 12th January 2021, the service of the respondent was regularized with effect from 26/6/2012, rejoining that on instead of
No, it cannot.
5th January 1919.
No, that you have written, or where is the document?
My lord,
Where is the document to that?
document, my lord, annexed, sir.
You were regularized on?
My lord, regularized.
In 21.
Yes, my lord. On 21, regularity, page 48 of the writ appeal, my lord. My lord, page 48, annex of forces, pursuant to the government in so and so, SME, both dated so and so, communicated by memo number so and so, of the Directorate Elementary Education, Orissa Bhubaneswar, and in compliance of the order of the Honorable Court, OJC number 6447 of 2000, filed by the State of Orissa versus Arjun Charan Mohanty and another against the order dated 10/3/2000 in way number 2583 of 1999, a base case, and as per the Directorate letter number so and so, the services of Kishore Chandra Sahu, the petitioner, my lord, illegally appointed as government eliminated teacher during the incumbency of late K.C. Guru, ex-inspector of school, Sambalpur Circle, Sambalpur, in irregular manner by office order so and so, as 12 district inspector also, Rairakul, case 12 inspector of school, Sambalpur Circle, Sambalpur, and who joined Bantoli, PS, Rairakul block, and now continuing so and so under block education officer Jojo Mora, is hereby regularized with effect from 27th June 2012.
Regularized on 26/7/2012.
My lord. My lord.
But
from the date of
then
reinstatement to
Mr. Panda, just verify. 26/7/2012, you said they reported for duty. May not be correct.
Then it will be 27/6/2012.
27/6/2012 is regularization date.
Yes.
Therefore, he was out of the employment. Your version is not, may not be correct. How you will regularize if he was out of employment? At the most, what it can be is the order dated 10/3/2000 made in OA 97 of 2000, along with other matters, were put in challenge in OJC. OJC took 18 years for disposal. Very short period. Regulation matter. 18 years is taken for disposing of the OJC. And in the meanwhile, on 26/6/2012, we had regularized the services. Pendency of OJC itself. OJC came to be decided.
Then with a condition that last two lines.
Subject to outcome of this one. But that will not help you anything because OJC it turned out to be in their favor. It allowed investigation, etc. Then what is there in your matter? Delay is there.
Delay perhaps condoned earlier, my lord.
In other cases, delays are not condoned, but I don't have any objection. That all may be hard on merit, my lord.
Delay is condoned already. 27/2/2025.
In this case, delay condoned.
Yes.
In some other cases, tagged some other cases.
Which are today,
my lord.
In that list.
But I don't have any objection for the delay.
My lord, there was a scam that CBI and that investigation was there. Hastily, I will pray that only some time may be granted so that I can consult the department at what stand, uniform stand they have taken.
My lord, WPC 1,
uniform stand has been taken to regularize. Then the notional period already have been excluded by the single judge. Only pensionary benefits they will get because we ourselves have regularized. We ourselves have regularized subject to condition. That I admit to that. That after seeing that order, then only instruction I will seek. What is the gamut of the case? That is a very peculiar scam, etc., my lord. The whole gamut I had to go.
Since 23, my lord, he is not getting a provisional pension. Very old man.
Not getting provisional pension.
not getting the provisional pension. How you-
Provisional pension, my lord, that has to be given, that I concede. Because provisional, we have regularized, we have retired him. Then he used to get that. If it is true, then I have to
It
encourage
is
him.
200% true. I will make
I'll
a-
come back to your lordship. I'll come back to your lordship.
We have invested a lot of time in this matter. Anyway.
I'm so sorry, I was not intending
No, it's
to.
not official. We understand. It's in all the sales, very police investigation.
Yes,
There.
checkered career.
Well, it's similar.
On 23/7. Yes. Yes. 23/7. Yes.
Right.
Well, on item 21,
Yes.
the state is substantially aggrieved by the order of the London single judge. Your lordship may kindly take up the state appeal. There are 3 appeals, and one appeal is by the state, where the sum and substance of the, that is WA number 3344 of 2024.
It is not 21.
I'm sorry, I'm arguing 22. Sorry, I'm so sorry.
21.
Your lordship's at item 21, my senior is on her leg, she could not appear, so can I please ask for a passover?
Passover.
Yes.
No, we are not taking people. Passover may not be feasible. No, you take some date. Because this first week of August.
Sir, it's a very serious matter, sir.
Therefore, on August first week,
10th.
Yes.
Sir, one thing, sir, one prayer is, I have filed one additional affidavit. That has not perhaps reflected in the record.
Registry to put up additional affidavit.
I have a copy with me, but it is not reflected in the registry.
Lord, first, your lordship will take up the appeal by the state, that is WA 3344 of 2024. All the 3 appeals are against a common judgment passed by the Honorable Single Judge. Well, the issue is that the state intended to fill up the post of lecturers in all non-government aided educational institutions, colleges, non-government aided colleges.
We are not taking this matter. It requires deeper consideration.
No. Only. UGC regulation will prevail over the state or not. That your lordship was last occasion saying that it has been settled by the Supreme Court. I have examined Supreme Court decisions and I have come with those decisions before your lordship that unequivocally in every judgment the Honorable Supreme Court is saying that unless adopted by the state, it cannot be imposed upon the state. Federal structure, my lord, the state is to man its institution, and the higher education is the entry number 66 of union list. That for that, but there is a distinction in the union list. Your lordship may kindly have please consider that 66 entry in union list says.
But this requires a deeper consideration.
Coordination is there, my lord.
No, that's all right. But matter requires deeper consideration.
This particular case, I'm appearing to the respondent in the first case. My learned friend may not be correct in saying that the state has not adopted the UGC resolution. The clear finding of the learned single judge is that the state has adopted by a notification. The lordship would kindly turn to page 270, the impugned order. Lordship would kindly see.
Anyway, let me come before some other page. 23rd? 23rd? Yeah.
And subject.
Whichever date you want.
22nd. So here the entire selection process has been stopped.
That's why we are eager for disposal, my lord. We are before
not 26th.
Subject to your lordship's convenience, we don't want to trouble your lordships. But can it be 13th, Monday? It will hardly take 15 minutes of
No, I am not taking any, since I'm an outgoing judge, all matter, complex matters.
Sam, sorry.
Last week of July 2026. Yes.
particular date.
In some way. In some way.
Let's a small prayer. If IA for intervention may only be considered, that's all, because we have filed every time the matter is not reaching only IA. The issue is we are the candidates, we are the petitioners who are having NEET certificates. Now the UGC regulation says PhD and NEET. Now the state government's issue is they are using the UGC regulation partially. They are saying for pay fixation we will be using the regulation, but for qualification, essential qualification, we wouldn't be using that. For that reason, since the last 3 years, no recruitment has happened. We approached the learned honorable single judge. Single judge, before the single judge instruction was given that till the writ appeal is not disposed of, no appointment can be done. So honorable single judge also instructed us to intervene into this matter. We are necessary party, directly getting affected.
Any objection for allowing the intervening application?
I think my learned friends.
Intervention, we are not having any objection. On
interruption is also there, Lordship.
Two applications. Three.
Yes,
three applications in IN number so and so. Right down and give. Supported by separate affidavits are moved seeking their impleadment on the ground that they are proper and necessary parties in the light of decision of Apex Court in Rajia Begum versus Shahnawaz Begum, 58 SC so and so. First off, the impleadment, except elongating the cost title, would not cause any prejudice to any of the parties. First off. Further, their impleadment would be doing complete justice, would be facilitative of doing complete adjudication of issues involved once for all. First off, in the above circumstances, the subject applications having been favored, the appellants are directed to array the applicants as respective respondents to these respective appeals.
But in the meantime, because we are eager for disposal, in the meantime, Lordship fixed of 929. In the meantime, let them not precipitate the contempt.
Contempt you should not precipitate.
No contempt has been filed.
If they have filed a writ petition because the contempt period has over. Now they are proceeding in a writ petition.
That date only will mention the writ application.
Learned AGA Mr. Panda subject that
number 4
submit and learned advocates appearing for the completed parties agree that the writ petitions pending before the learned single judge would not be precipitated till after the disposal of these appeals.
Great.
Yes. Next.
23.
I am appearing from the appearing for the October 3 and in the second I am appealing for the petition. And for the October 3, already filed the counter and served the copy of it. While in the next petition, we have received the counter and we will file the rejoinder.
Want to file the rejoinder?
It's a matter of industrial adjudication, whereby the learned tribunal has although where that the petitioner members of the union are workmen under the provisions of the Industrial Dispute Act, but they declared the relief on the ground that there is a delay. So that
was it a case of reference?
Yes, Lord.
Reference?
Yes. It's a reference of 2012. The matter was challenged by the management of Hindalco.
You file a rejoinder within 1 week.
Yes.
Rejoinder, if any, may be filed within 10 days. After serving copy thereof on the learned counsel appearing for the petitioners.
Yes.
First of put this matter in the last week of July 2020. Yes.
24.
Before my lord, maybe taken up some other date. My lord, I strongly object.
But we want to adjourn.
Right.
We are not in a basic 2026 matter, na? Yes.
But the cause of action has been here 2010.
2026. On the request. Yes.
Interim order.
Interim order to continue till the date of hearing. Okay.
25, 726.
Item 25 for the opposite parties. Hence, counter is ready, will file by next week.
Mr. Patil of the DSP.
Lordship, may I please, Lordship? Lordship, may I please, Lordship? 3 occasions they have taken time, Lordship. Lordship, Lordship, next week kindly come, let it come.
This is a small accommodation, first time. 10 days granted for doing the needful, failing which right to file the counter stands extinguished. Call this matter on 26 July.
17, Lordship, 17, Lordship. I pray for 17, Lordship.
17.
Lordship, 17. I pray. It will take only 5 minutes to my Lord. It will take only 5 minutes to my Lord. Only one annexure I will show it to my Lord.
Next.
Lordship, any date?
22nd. Yes.
Item 26.
Please, Lordship. Very short question here is involved, my lord. The DRAT remanded the matter by setting aside, in fact, not set aside, it is simply remanded the matter to DRT for fresh consideration. The securitization application favored me, my lord. Bank challenged that in appeal. In appeal, my lord, in the appeal memo, there is no ground made that the evidence they want to adduce, that was either not in their custody by the time of the securitization application was pursuing, or they were prevented by some natural cause to file it. Simply without any reasoning, it has been demanded.
John, to another date.
Call on 22nd. 22nd. That the request of so final.
Oh, that's your options.